Okay, so today's session is all about leasehold management, breach of lease. It's a part of the buildings block sessions, which is something aimed at people at the beginning of their careers. For this particular session, those who are now working leasehold management. What do you do when your leaseholders have breached the lease? What are the legal remedies open to you? This is a big part of what we do. So this session is just covering really the basics and sort of the scenarios you might find yourself in and what the possible options are for you to remedy the situation. Okay, so I'm going to talk about understanding the lease. So basically the format of the lease, what it looks like, what you should be looking for in the lease when you have a look at it, assuming you have a copy of the lease, which hopefully you do. And then I'm going to start talking about remedies for breach of lease, and I'm going to cover injunctions. And then we're going to have a Q&A or a quick question and answer session on injunctions. Then Zoe will go on to talk about money claims and forfeiture. Lucky Zoe talking about forfeiture, that's always everyone's favourite topic. It's also Zoe's birthday today, so happy birthday, Zoe. So do be nice to her. Obviously, feel free to wish her happy birthday, apart from the fact we might not see the questions as they come through. But happy birthday, Zoe. Thank you for doing this with me. Okay, so the types of lease that you may encounter in your role, working generally as registered provider, but also local authority, the types of lease that we're talking about today. So these are long residential leases. General leases, they might be 125 years, they might be 999 years, but they're residential leases anticipated to last for a long time, and you will typically be the freeholder, but you might be a head landlord, so you might be subject to a lease yourself, and the property may be ultimately owned by another entity who is the freeholder. So you have duties to your leaseholders, and then the freeholder in turn has duties to you. And it's a big chain of liability potentially, and responsibilities as to who pays for what. There's also within that, particularly in this sector, you may come across post right to buy, right to acquire leases. These have their own peculiarities, so that they look slightly different to your typical leaseholder lease, and they need a bit of careful reading themselves. Another peculiarity is something called a shared ownership lease, which is technically not a lease, but it's an assured short-hold tenancy, just a really long one until they staircase up. But we're talking about them briefly today, just because a lot of the obligations will be as for any other leasehold property, but the actual legal entity itself is technically an assured short-hold tenancy. The other leases that you may use or may come into contact with are commercial leases, say in the bottom of your buildings or so on, where you might have offices yourselves. That might be something that you end up looking at, or you may be letting out to businesses, local businesses within blocks and so on. So they're all leases, and they're all longer than tenancies. They've all got their own peculiarities. And the one thing that I will say is that whenever we get a question about any kind of leasehold query, we always ask to see the lease. That's because they're not all the same. They've all got their own provisions, and ultimately the answer should be within that lease. Sometimes it's not, but it should be in there. There should be something in there that will give us the answer to the question. It's just the way that it's written might be quite difficult to interpret, which is where we come in as lawyers, basically, and that's where our training helps us to help you. So the information that's contained in the lease, what is contained within the lease? Okay, so it should contain details of the property itself, the demised premises, what's being leased out, the land that's being leased out, the extent of it, what it contains, does it include windows and doors and so on. It should give a full description, ideally, of what is and isn't included within the demised premises, what you own as a leaseholder or what your leaseholders own as leaseholders. It should also have certainty of term. It should say how long the property is leased for. So it might be phrased as 125 years from this date. It might give the end date. It might, it could give any period of years, really, but typically longer rather than shorter. It will describe what is to be paid and when. So it will talk about ground rent, what should be paid, you know, should it be paid quarterly, yearly? Is it a peppercorn rent? It will also talk about service charges, which I'll come on to. So I've just had somebody saying they can't see the slides. I assume everyone else can see the slides. Yeah. Okay. Sorry, for those who can't see the slides, hang on. Yes, someone says yes. So do keep fiddling with your settings and hopefully you will get to the slides rather than our faces. Perhaps if you reduce our faces and shut down all your other windows, you might see the slides, hopefully. There will also, or quite often, there's details about what the property is to be used for. So typically it's a residential property and so on. There will be details in there of obligations of the leaseholder and also you as the landlord of what you should be doing, what you're obliged to do, behaviours and so on. So repairing obligations, access obligations, the fact they shouldn't be causing nuisance, all the usual kind of provisions that they should be undertaking as leaseholder for the property. There will typically be details about what services you will provide as a landlord, i.e. You will keep the communal areas clean and clear, you will be responsible for maintenance, you will clean the windows in the block, but you won't clean the interior windows of the premises and so on. So it should detail, hopefully quite in a fair bit of detail, what you're obliged to do. But older leases may not contain the same detail. So it really depends a lot on the lease itself. And hopefully it should also include details of where the cost of services can be recharged and where they can't. And where you come into difficulties sometimes is where things have changed. So say fire regulations, cladding, all those kind of things weren't thought about, you know, 20 years ago, 30 years ago, 100 years ago. So, you know, those services that you're doing, and this is where the problems are arising, is because there's no details in the lease about who's responsible for paying for what. So, you know, the leaseholders will say, no, it's you, the landlords will say, no, it's you, the leaseholders, and there's actually nothing in the lease. So this is where the government's having to step in. Okay, so in terms of what you typically see when you pick up a lease, they all look a bit different. Older ones in particular are often very legalistic. They will use terms like hereby demise. They will talk about easements, rights, privileges, covenants. Use quite old legalese, basically. Whereas your tenancies, if you've worked in tenancy management, often quite clear and simple. Even older ones will be a lot more simplistic. But leases, often they're quite old, and even nowadays they use a lot of legalese. They will talk about covenants and other things. So it's harder as a layperson to interpret them potentially, which is where we step in sometimes. In terms of layout, what usually happens, the way they usually run, is that they will have the particulars and definitions at the start, i.e. what the lease comprises, what the terms of the lease, what the property is, and so on. It will give the definitions within the lease, who the parties are, and you know, what we mean by ground rent and so on. So if you can't find it within the body, it will be in the definitions. It will talk about the property being leased, as in what the dwelling is, the duration, and the ground rent. It'll then go on to talk about what you're required to do. It will talk about what your tenant is required to do. So it'll talk about what services you are expected to provide as landlord, and then in turn what the tenant's expected to do. So they are usually responsible for the interior of the property, but they're also responsible for paying for the services that you've provided, i.e. to the communal areas and so on. Okay, so I'm going to talk about remedies for breach of lease now. So what are we talking about really when we're talking about breach of lease? So when people come to us, when clients come to us, it's because a leaseholder's not doing what they should be doing. Typical breaches that I will see would normally be about things like they're not complying with their repairing obligations. So I've had a couple of cases where it's things like they're not, say they've got a bathroom, their first floor flat or a flat above another property, they haven't sealed the bathroom correctly, so they've not put in the usual sealant and the leaks are going down to the property below and actually causing real problems. Those are typical type cases where it's nuisance coming down to the other property because they're just not doing what they should be doing in terms of their obligations within the lease. Or perhaps they have done something crazy, they've changed the complete interior of the property, they've removed walls, they've done something strange to the property which is in breach of their lease. They haven't talked to you about it, and you're worried about the condition of the property. There could be all sorts of things, or they've sublet the property. Usually that's allowed, but actually for shared owners, not so much. So they shouldn't be doing that. So there's all sorts of reasons that you may come to us for an advice. So then we look at things called Part 8 injunctions, which is where we're taking injunction action purely on the terms of the lease, their obligations to you, or potentially nuisance, or as in statutory nuisance because of disrepair, or or trespass potentially if they're coming onto your land for some reason, or somebody else's land. There's also instances where we get instructed where there's antisocial behaviour, usually by the tenants. If the breach is sort of antisocial behaviour, then we can issue, if you're a registered provider of social housing, which the majority of those logging in will be, you can apply for an injunction under the terms of the Antisocial Behaviour Crime and Policing Act. So that's quite often not against your leaseholder potentially, but maybe against subtenants if they're causing problems to other neighbours in terms of antisocial behaviour. Somebody has asked what Part 8 comes from. So Part 8 is just relates to the name of the claim. I will come on to the questions later, Zoe, don't worry. In terms of, and then other remedies you might be looking for, money claims. So this is where somebody's not paying their service charges. Quite often it's in relation to major works. They're disputing them because suddenly they get a bill for £20,000 and they think, what's this for? Ignoring the fact that you've served them with all the Section 20 information previously, they suddenly get the bill and realise what it all meant, and they should have objected last year. And then other legal action you may take if none of the above works and you still your leaseholder is causing real issues, then you may go on to consider forfeiture proceedings. Okay, so I'm going to talk about injunctions. Then after I've, which I'm going to get on with fairly quickly, then we're going to have a quick Q&A, and then Zoe will come on and talk about money claims and forfeiture. So injunctions, basically what do we mean? We mean something where we are asking the court to ask your leaseholder that either they stop doing something or they have to do something. So if they're doing something which is causing issues, i.e. they've not fixed a tap, for example, and it's leaking everywhere, then they need to basically stop doing that, or they haven't filled in sealant, so they're water is continuing to egress from their property, then they need to do that. Or if they're causing noise nuisance, for example, the nuisance cases, then they must stop playing music between a certain time, or causing anything that to be heard outside the premises between a certain time of night, and so on. So basically an injunction is something that you're asking someone to do something, specific performance, or you're asking someone to refrain from doing something, i.e. just abide by the terms of their lease and stop causing problems for the neighbours. If you already have an ongoing claim, you can bring in an injunction within that. It's not typical for leaseholder claims, really, and generally they are issued as a freestanding claim. So Part 8 claim would be a freestanding claim, usually in terms of breach of lease. So when we're saying Part 8 claim, it's just basically the way we're getting in through the civil courts. We called it Part 8 claim because it shouldn't be disputed. It will be. So it goes under Part 8. It's not just a money claim. We're actually asking them to do something. Or under statutory provision, so the Antisocial Behaviour Crime Policing Act, typically if we're talking about nuisance cases. And the reason we would be seeking an injunction and we'd be advising you to go for an injunction is where you need to get a quick answer to something. So you need somebody to stop doing something or start doing something very quickly. So there's a repairing issues which are actually a danger to other people. Or there's a leak, as I've already talked about. With these fire regulations, actually, we need them to replace their fire door. They're obliged to keep the door in repair, but they're not doing it. You want them to do it ASAP, so you will seek an injunction to get them to sort the fire door out or do whatever they need to do to make sure that any risk is averted from their side. Quite often we will get access injunctions, so where we think something's going on with the property, we're not sure, we just want to go and have a look, see what the issues are. If the leaseholder's not letting us in, then we can apply for an access injunction. Antisocial behaviour, so by the leaseholder, quite often by subtenants, any kind of antisocial behaviour, noise, nuisance, threats. We don't tend to get it that much with leaseholders themselves, but it may well be subtenants we tend to get it from, or unauthorised subtenants. And quite often where I've been instructed, it's all about unauthorised alterations. I mean, it talks about satellite dishes, but it's more actually moving walls and doing other things where landlords might want to step in, actually affecting their property. So I'm just going to show you a case study so you can see an example of what a typical instruction might be and where you may have typical issues. So this was a lease that started on the 31st of March 2008. So not an ancient lease, it's fairly modern. But there's a clause for this property, which was a first floor flat, not to make any alterations or additions to the exterior of the property or any structural alterations or structural additions to the interior of the property, nor to erect any new buildings or in any way to interfere with the outside of the building. So in this case, our client came to us. They had a leaseholder who basically built an extension without any consent, without letting us know. Obviously, the neighbours got in touch. And when we looked at it, we were very worried about the safety of this extension. And you can see from these photos why, because I don't know if you can see, but there's basically two little poles holding up this basically extra bit of building they've just created there. So yes, the client was a bit concerned about this and what it all meant. They hadn't sought permission. This was just for the first floor flat. Obviously, this is not very satisfactory, just building without letting anyone know. So the neighbours underneath, we were quite concerned about this, understandably. So what do? With any injunction, assuming you have time, it's not serious violence, then you will send a letter for action. We sent them a letter for action, asking them to provide us with details of how they intend to rectify what they've done, or we will issue proceedings. What are they going to do? Have they got building planning permission? Have they got building consent? What is going on here? And what are they going to do here? There was no response, so we issued a claim asking for an injunction requiring the removal of that extension, that alteration they'd done without permission. The leaseholders then took steps to make sure it was all compliant, so they got the building regulators out. We then offered to settle and provide consent on the basis that they paid all our legal costs. The leaseholders entered into a license for alterations and agree a deed of variation. So these things are sometimes you can rectify them in retrospect, but if your leaseholder's not talking to you, actually you need to get an injunction in place to actually sort it all out and make sure everyone feels safe and what they're doing is safe and you're happy with it. Okay, so for antisocial behaviour, so this is these are more specific under the Antisocial Behaviour Crime Policing Act. So an injunction might perhaps stop someone from doing something. So if they're causing noise nuisance, typically, then it's that kind of thing. Or if they're leaving items in communal areas, that they've got to stop doing that. all those kind of things they might be doing. They might be asked to do something described in the injunction, i.e. clean the property, or stop, playing music, abide by the terms of the lease. If there's violence, you can include a power of arrest, or you can ask for a power of arrest, and it can be included. Again, if there's violence against neighbours or anyone in the property, then you can exclude somebody from their residence, actually. So it does contain provisions for exclusion order as well. Again, antisocial behaviour injunctions, the way they differ, so you can apply, if any injunction is breached, you can apply to commit the defendant to prison or fine them. You can also use that breach as a determination of the breach of lease, but they have to make a finding of fact of breach, or you can seek a declaration of breach with the injunction application. So when you're applying for the injunction, at the same time, you may want to seek a declaration of breach, and this could be, this would be useful potentially for later forfeiture proceedings, which Zoe will come on to talk about. So there are advantages. So basically, when we're instructed, we will talk to you about what you want to do. What do you want to achieve here? Is it that you're absolutely fed up with the leaseholder, and actually the relationship's really broken down, they're not paying anything, they're not doing anything, they're causing you no end of problems, in which case actually you're looking for forfeiture, in which case you may think of a long-term strategy here, what you want to do. Do you want to get a declaration? If it's something where you need to act quickly and actually the relationship's not completely broken down, you just want them to behave themselves or do what they should be doing, then an injunction may well be more appropriate and the end in itself, really, of what you're seeking. So the advantage of going for an injunction is that you can get it quickly. You can get it potentially against tenants, so not your leaseholder. So if it's antisocial behaviour, you could get it for people who are occupying the property, and you don't have to have that direct relationship. You should get costs against your leaseholder if you can show the breach. The disadvantages, so courts are reluctant to commit to breach. So if somebody has breached an injunction, the court's not automatically going to give them a custodial sentence. It would have to be quite serious or involve violence. The other disadvantage, if you were going for antisocial behaviour, power of arrest, it removes your power potential. Well, it doesn't remove your power. It means the police will go in and arrest and do what they should be doing, but it does mean that actually you end up going back and forth to court quite a lot and incurring costs where you may think actually these breaches are not really what we would normally be going for, but obviously in certain circumstances it is completely necessary to get power of arrest. Injunctions are only ever enforceable against somebody who's got the capacity to understand the terms of the injunction. So if there's any questions about a resident's capacity and whether they would understand what you're doing or not, then that's something to be considered carefully, because you won't get an injunction against them. If it's purely on the breach lease, you might have arguments later about the injunction constituting basically relying on the breach further, so it might cause problems with forfeiture later, but that's quite technical. I wouldn't counsel not going for an injunction if it's appropriate to go for an injunction just on that basis. Has anyone got any questions at this point before we move on to Zoe? Okay, I can see there's a question. If a leaseholder is leaking into another leaseholder and not carrying out works to remedy, should the freeholder get involved? Well, yes. I mean, obviously the leaseholder may well have mutual covenants they can effect against the leaseholder themselves, but quite often they'll come to you. You're the one with the power and the money, and they will expect you to enforce the covenants that you have on your lease with the offending leaseholders. So you'll be writing to them, asking for access, asking what they're doing to try and remedy the leak, and provide you evidence of that, and really pushing on it. And potentially I'll be looking at getting an injunction to get them to do the works, or to get in yourselves and actually carry out the works and then recharge them. So yes, you will probably have to get involved, especially if the leaseholder comes to you and asks you to basically help remedy the situation. So a declaration of breach, that's something the court can do to say that the court will declare there has been a breach of lease. Once you've got that declaration, well, it depends on whether the breach is remedied. Well, you can fix the breach or not, but if you can't, then potentially that'll give you the basis to serve a Section 146 notice and then start going down the route to forfeiture. So it's certainly worth obtaining. Okay, so someone's got a leaseholder with rent arrears. They've also raised a disrepair issue. They're saying they can't pay to do the repairs, although it's their repair liability. Would you raise two injunctions, one for arrears and one for disrepair, or would it all be on one legal claim? Well, if it's their obligations, then they should be carrying out the works. The fact they can't afford it is not really your problem. But equally, I don't know how effective an injunction would be if they're saying they can't afford to fix it. If it's something that's affecting another property, you might want to get an injunction to get in and do the works yourself, then recharge the leaseholder and look at it as a money claim later, potentially. It's a tricky one, I would say, that one. Zoe, have you got any thoughts on that question before you go on to yours?
No, I think I'd agree with you on that question. That is tricky, and it totally depends on the exact circumstances, I think.
Yeah, okay. Right. Okay, I'm going to pass on to you, Zoe, now.
Right, so good morning, everybody. So money claims is what I'm going to deal with first, and then I'm going to talk about forfeiture. Money claims shouldn't take too long to discuss, and there's more slides on forfeiture. Next slide, please, Anna. So money claims. So you would go for a money claim if you are considering forfeiting a lease, or indeed if you don't actually want to forfeit a lease and you do just want a money claim to try and enforce, or if you're not sure what you're going to do, then you might bring a debt action. As it says on the slide, it's a typical starting point for forfeiture proceedings relating to debt, so other than rent. So for service charge or for administration charges, etc., unless your lessee has admitted that the sum is due. So in order to forfeit, you need either a determination of breach or an admission by the leaseholder. I think that's Section 81 of the Housing Act. Admission is a funny one when I'm asked about this by clients, because if you get an oral admission, for example, from a leaseholder, and then you rely on that to bring a subsequent forfeiture claim, and a leaseholder then later down the line says, I didn't admit this breach, you have to be able to prove that, and you will have gone a long way down your forfeiture route and incurred a lot of costs and spent a lot of time to then have to try and evidence that the leaseholder did definitely admit the breach. So if you're going to rely on an admission, I would say make sure your admission is worded so that it's very clear that the leaseholder is admitting that the whole debt is due and payable. So determination by the tribunal is a possible alternative to a money claim. Where it's just a standard money claim for pretty low value, like these ones are likely to be, you wouldn't normally choose, or I wouldn't normally advise issuing in the tribunal, but it does have the jurisdiction to deal with it, and so you could consider tribunal proceedings. Straightforward procedure, small claim, if it's under £10,000, a small claims procedure is pretty fast. Supposed to be very straightforward. It's just a claim form particulars that you send off to the court. Your leaseholder defendant will then be served with those proceedings and will have a certain period of time in which to defend if they choose to. As it says on the slide, leaseholders often don't defend, and that's either because they're not actually residing in the property, which might be a reason why they're not paying their service charges or rent arrears. The leaseholder might not understand what the proceedings are when they receive them, or they might simply not care to respond. So you often get leaseholders not responding, and you can then, if they don't defend within the requisite time period, you can then apply for judgment in default, which is then essentially your judgment for your money claim. Next slide, please, Anna. So enforcement possibilities, I've always found these pretty difficult to advise on, because if I am honest, they're not particularly good enforcement options as far as I'm concerned. I think it depends, actually. So a warrant of execution, if you know your leaseholders have some very expensive cars that are registered to them and that they own outright, or they have some other very expensive goods, a warrant of execution can assist you in that you can apply for a bailiff to attend and take possession of those goods until such time as the money is paid, or to use to pay towards the debt. You have to be careful if things are owned on a hire purchase or any kind of lease, because then they're not actually leaseholder owned. Third-party debt orders, so that's freezing of bank accounts. Now, they can be useful if you know your leaseholder has significant amounts of money in the bank, but you're not that likely necessarily to know that. So, and you might not necessarily know all the bank account details. You might, obviously, if you're receiving a service charge from them, but you might also not know them. And it only freezes the bank account on that date for whatever sum is in that account. So actually, if your leasehold doesn't have huge amounts of money in that account or has any idea you might be making one of these applications, leaseholders can move money from accounts, and therefore it's not a particularly great remedy to get. So that again is situational. Attachment of earnings, so a deduction from wage at source. Now, these can be good, or certainly the threat of them can be good, if you have a leaseholder who has been in employment at a certain place for a period of time and would be embarrassed by the fact that their employer will be getting a copy of the court order and a request that some of their earnings are coming straight out of their wage every month and going to you to repay a debt. The problem with attachment of earnings is, again, you have to know where your leasehold is employed at. And depending on what they earn, you generally get a very small sum every month returned to you. And it's a bit administratively burdensome. And obviously, if they leave employment and move to somewhere else, you then have to go through the whole procedure again. So again, they can work, but it totally depends on your leaseholder and where they work and how long they've been in employment, etc. A charging order. So once you have a debt, you can apply to put a charge on the property. Now, again, they can be very useful, but what I would advise you do is you look at the title first, because a lot of properties owned by leaseholders will have a mortgage on. So you will have a first charge holder who has a mortgage, and you're not that likely to know the amount of the mortgage. So you would then rank not as a first charge holder, as a subsequent charge holder. You might not actually know whether there's any equity in the property that would allow you to actually recover those sums. Now, you can get an order for sale and a charging order, but it's not a straightforward procedure. So the likely chance is your charging order is just going to sit on the property until a sale. If the leaseholder doesn't sell that property for, say, 50, 60 years, you're not getting recovery of that debt. So it's a possible option. And again, it can work if someone's considering selling their property because it sits there on title. So anyone looking to purchase will see that. And again, it will obviously have to be repaid before the sale takes place. Now, oral examination, if you don't know your leaseholder's financial means, you don't know if they're employed, you don't know what money they've got in their bank accounts, etc., you can ask them to attend court for questioning to answer some of these things so that you then can consider one of the above methods. But again, that puts them on notice that you're potentially going to do one of these things, which can present a problem. Next slide, please, Anna. County Court Register credit blacklistings. So if they don't pay the debt within the time specified, if they don't pay the court order, they go on the County Court Register, they have a CCJ against them, and that blacklists them for credit applications. So and for things like mortgages, credit cards, etc. So you might find that, again, that's enough. If once you've got the judgment, you write to the leaseholder and explain to them what's going to happen, in terms of that they will be blacklisted, and in terms of all the other potential enforcement options that you have, that may well then be enough for them to pay off that debt. Next slide, please, Anna. So forfeiture, really complex topic. So I'm trying to do a whistle-stop tour of this one, but it's really complicated, forfeiture. So for a breach of the lease, for a determination of breach, the Common Hold and Leasehold Reform Act says that a landlord can't serve a Section 146 notice to forfeit a long lease of residential premises for a breach of covenant unless that breach is admitted by the tenant, or a court has found the breach has occurred, or a tribunal determines that the breach has occurred. We've talked about what you'd need in terms of an admission, and then we've talked about the need for example, getting a money claim, which essentially is a declaration that the breach has occurred because you'll get a money claim for the debt, or an injunction with a declaration that they are unlawfully subletting, or a court order that says that they're subletting or they've made unauthorized alterations, etc. So you do need a determination of breach. And the tribunal has the authorization to make a finding of a determination which does amount to a breach of lease. Next slide, please, Anna. The question for the landlord is whether it's quicker to get a declaration from the court or a determination from the FTT. Now, this is a bit of a loaded question because courts are pretty behind with their schedules at the moment. They weren't that brilliant to start with. I'd say if you're going for a money claim, they're still pretty quick, or small money claims. They're not too bad. Tribunals do tend to be faster, I would say. But ultimately, I think where you're going to issue probably does depend on what you're issuing in relation to and whether the court or the tribunal will be the better forum to deal with your matter. So it's not necessarily just speed, but I do think that's something to take into account. And you can combine applications in the court. So, oh, sorry, Anna, we've gone on one. Someone had asked this question essentially in relation to two different issues, but if you've got antisocial behaviour, I don't actually think that this is what this slide means, but if you did have two different things, so antisocial behaviour and an unauthorised subletting, you can bring an action for both of those. But I think what this is getting at is that you can get more than one remedy. So you quite frequently see on claim forms that come in that they're applying for a determination of breach, so an order for costs. They also want a declaration that the breach has occurred, and they also want injunctive relief. So for example, if it was antisocial behaviour, you might have an injunction to stop their behaviour, an injunction to exclude them from the property, and you might also have an order that says that there's a declaration that the breach is made out. When you've got that, your declaration of breach, you can then serve a section 146 notice. Next slide, please, Anna. So forfeiture. In order to forfeit a lease, you have to have a re-entry clause in the lease, and some landlords do overlook this and just assume that there is a right to forfeit. There are leases that don't contain forfeiture clauses. They are few and far between, but there are them. So always as your starting point, particularly if you're doing your 146 notices and your money claims, etc., in-house, the first thing to check if you're considering forfeiture is the lease and see whether there's a forfeiture clause. And it will look something similar to what's on the screen, but it will contain the words re-enter the premises or repossess the premises is essentially what you're looking for. This clause then allows the landlord to forfeit, so go through some of them steps that we've already talked about to forfeit the lease. Next slide, please, Anna. So restrictions on forfeiture. Before taking an action for forfeiture for anything other than non-payment of rent, the freeholder must serve a notice pursuant to Section 146 of the Law of Property Act. There isn't a specified form of notice, but there's certain information that has to be in your 146 notice, which I sometimes think makes it harder when there's not a specified form, but you have to contain certain information, has to be contained within it. So you have to state that there's a right of re-entry in the lease, and you have to specify the breach complained of. So if it is a antisocial behaviour breach, you need to specify what that breach is. If it's an underletting breach, specify it. And if the breach is capable of remedy, require the lessee to remedy that breach. Most breaches are obviously capable of remedy. If it's antisocial behaviour, desist from behaving is remedying that breach. If it is that you have service charge arrears of £10,000, you can remedy that obviously by paying. If it is an underletting, you can remedy that by stopping the underletting and going back into possession. So most breaches are capable of remedy. You have to give your leaseholder a reasonable time to remedy the breach. There's nothing that says what a reasonable time is, and that's situational. So in Anna's case study example, someone trying to take down that huge extension isn't something that they're going to be able to do in a week. It was pretty rickety, so maybe, but it's likely to take them a lot longer. That's likely to require longer as a reasonable time than, say, desisting with any antisocial behaviour. So a reasonable time. We would normally say 14 days for like a financial breach, but it depends on what your breach is. Next slide, please, Anna. So we've already talked about this, but Section 81 of the Housing Act and Section 168 of the CLRA 2002 require there to be an admission or determination of breach before a 146 notice is served. And that's determination from the court or the tribunal or a finding of fact. The next slide, please, Anna. This one's really important when it comes to financial breaches. And a landlord can't exercise their right to forfeit for rent, service charges or administration charges where the unpaid amount is £350 or less. unless the amount is less but has been outstanding for more than 3 years. So I have actually seen leases been forfeit for ground rent of, say, £6.72 because it's been outstanding for more than 3 years. Now, you've obviously got to be careful about waiver, which you come on to, but the £350 is important because you do need to consider what the arrears are. But also, if they've been outstanding for more than 3 years, there still is the potential, even if it's a really small sum, to forfeit. Not that I think that housing associations generally would forfeit for very small sums, but the £350 is an important figure to remember there. Next slide. When you're faced with a breach, there are two options: enforce your right of forfeiture and treat the lease as being at an end, or treat the lease as continuing to exist. If you opt for number one, you must be careful not to waive your right to forfeit. And this is a really difficult concept, I think, to understand, because you make an election to forfeit a lease. And what forfeiture is it's that your lease no longer exists. So as a landlord, you're treating that lease as if it no longer continues. So you can't then be doing things such as demanding service charges, demanding ground rent payments, writing to them about Section 20 consultation, writing to them about, I don't know, something else that might be going on in their block, because that treats the lease in itself as continuing. So you waive your right to forfeit. Now, it's a really, really technical point, is waiver, and a lot of tenant solicitors aren't clued up in terms of what waiver is, and it's very tricky for the courts to determine whether waivers occurred or not. But it is certainly something to think about, particularly for larger organisations, because actually you have different departments that deal with your service charge demands going out, and they're automated, and it can be quite difficult to put stops on certain letters going out by certain dates. So it is just something to be aware of if you're wanting to forfeit, is the consideration that blocks do need to be put on certain accounts so that nothing treats that lease as moving forward, that you've taken an election to end it there. Next slide, please, Anna. Waiver, 3 ingredients: the landlord's knowledge of the breach of covenant, the unequivocal recognition by the landlord of the continued existence of the lease, and communication of that recognition to tenant. So if you're sending a service charge demand out, what you're saying to the tenant is, pursuant to your lease terms, you owe me this amount of money. So you're treating that lease as going forward. I think that's probably the best example in relation to waiver. Next slide, please, Anna. Once and for all versus continuing breaches. So again, it gets a bit more tricky in terms of what happens if you have waived your right. And I'm sorry, this is such a whistle-stop tour. So once and for all breaches, if you have waived your right to forfeit because you have somehow treated the lease as continuing, a once and for all breach prevents the landlord from forfeiting for that breach. You would then have to wait for another breach. So once and for all breach, that says on the slide, include but aren't limited to rent arrears, assignment of subletting, alterations, and failing to do something by a specified date. Now, the only thing I would say in relation to subletting is we do get quite a lot of Airbnb cases. And I have argued before, Airbnbs are obviously very, very short-term arrangements. They're normally 2 or 3 days. Some can be for longer, but they can be quite short. It's not specifically a subletting, but it does come into play in that, as far as I'm concerned, every single time you're letting on an Airbnb, there's a new breach arising because it's a new sublet or a new breach of the lease in that sense. It's not necessarily classed as a sublet, but Airbnbs are a funny one. So I just didn't want anyone sitting thinking that if one of your leaseholders is letting on an Airbnb, you might have waived your right. It's just something to consider. And continuing breaches, and this is that a breach arises afresh every day. So survives acts of waiver. So if you are still sending out demands, for example, these continue to arise every day. So breach of a repairing obligation, breach of an insuring obligation, and breach of a user covenant. So again, for an Airbnb, you're probably not allowed to let the property as an Airbnb, particularly if it's a shared ownership property. There might be a user covenant that prohibits that. So they are breaches that arise every day.
Sorry, I'm just going to add for Airbnb, it's often on the basis that they're not treating it as a residential property because they're not sleeping in the property for a certain amount of nights per week. So actually, that's quite often where the breach actually sits. Anyway, I'm going to sit on my hands.
Very good point, Anna. Thank you. Next slide, please. Oh, and I'm done. Questions, Anna? Do you want to take the first one if we've got any?
Oh, yep, we have got some. Okay, right. Okay, I'm going to answer a very straightforward question about injunctions, because I think that's to do with me, really. So if you apply for an injunction following the leak example, who would apply, who will pay? Well, it's winner takes all. Well, no, it's not. We would apply for costs, so the leaseholder should pay, assuming they are at fault. So you will get a costs order. It won't necessarily be all the costs that you've incurred, but it'll be what the court thinks are reasonable costs for those works. If you are applying for an injunction to do the works, to basically remedy it and then recharge your leaseholder, it'll depend on the terms of the lease, but assuming there's a recharging clause in there, you should be able to recharge your leaseholder for those works. Zoe?
An anonymous attendee has asked a question in relation to fire doors and refusal to upgrade. We do a lot of work in relation to that, and it's a really complex area that I don't feel like I can answer now. If you do want some further advice on that, please email me. My email should be on the end of these slides, because I really can help you in relation to that, but it's a complicated question, sorry. And I'll then take another one. Access for leaks. Can we force entry? No. You can't force entry if there's someone in that property who is not allowing you in. Your lease is obviously very likely to give you a right to re-enter if there is something, and it may well do that on an emergency basis. You may well be able to go straight in. A lot of leases, depending on whether it's a long lease or a short lease, etc., will give you as a landlord a right to re-enter that property in the case of an emergency. And you can do that, obviously, if there's someone in there that says, get out of my property. You can't force that entry, but you can apply for an emergency injunction to get that access to get in there. Do you have anything to add on that one, Anna?
No, I think you've covered everything. Yeah, it depends. I don't know, with a leak, it depends. If it was a gas leak, there's no one there, then potentially you could go in, cap it all off, come back out and sort it out later. But leaks, it depends really. If it's a water leak, it's quite often not that fast that it's gushing through, so it wouldn't be quite the same emergency situation. But there's usually provision for emergency, but it will depend on the lease and circumstances of the case. There's an interesting question about interesting questions. I'll probably get this wrong. If the council's granted an HMO license, so house in multiple occupation license, but the lease states one household only to use the property for the duration which prevails, I would say your contract with your leaseholder prevails in terms of you seeking a private remedy against them, so injunction or potentially forfeiture, regardless of whether the council's given a license or not. So if they're basically letting out the property to 2 or more households within that flat, and you've said no, that's not allowed, then I think your lease prevails. They would need to get an HMO license if they're subletting for more people, but that's on them as the landlord of the subtenants. So basically, in terms of the action you take, you rely on the lease and the breach of lease, regardless of the HMO. In fact, the HMO license would be evidence, I think, of breach, basically, because they've clearly let it to more than 2 households.
An anonymous attendee has asked, if as landlord we consented to subletting for a shared owner, but for some reason the terms were breached and we wish to apply for forfeiture of the lease, could we do so if a license was not issued? Now, I am making some assumptions on this question that you have granted consent on the basis that you'll give a license every time you sublet. It's not 100% clear. I think if you've given them consent, but it's subject to certain conditions and they've breached those conditions, then yes, I think you could apply to forfeit. If you simply don't like them subletting anymore, but you've given them the right to sublet, I'm not necessarily sure that you would be successful because you've given them that consent. And if it's that the consent is subject to a license and they've not applied for that and you've not issued that, then yes, again, I think you could apply for forfeiture. So I think that depends. That question's not 100% clear.
Yeah. So we've got quite a lot of questions, but we have really come to the end of our time today. So for those questions we didn't get to, do feel free to follow them up to myself or Zoe and we can look at them afterwards. And thank you very much for your attention today. there should be, after we log off, you should get an email automatically asking for feedback. Do give us feedback on today. And also, as I say, really importantly, please let us know if there's any other topics you think you would like to hear from us on, any other training you think you'd benefit from. Then let us know, and we can look at that as a team and see if that's something we can offer in the near future. But thank you so much for your attention. Thank you, Zoe. Happy birthday.
Thank you very much, everyone.